Hi everyone. My name is Ben Lossman and I'm the Communications Coordinator for TechSoup Canada. I'd like to welcome and thank you all for joining us for today's webinar on Canada's anti-spam legislation, presented by Zemmel Van Kampen, LLC, and sponsored by Volunteer BC. Before we get started, I'd like to quickly introduce you to TechSoup Canada for those of you that may not be familiar with us. Our mission is to help make nonprofits use technology effectively, and we accomplish this in two ways. The first is to make technology products more affordable through our Technology Donations Program. We partner with corporations such as Microsoft, Adobe, and Symantec and offer their products as either an outright donation or at a significant discount for charities, nonprofits, and libraries across Canada. The second way we help nonprofits is by creating and curating nonprofit tech resources. We write blogs, curate content on social media, and host webinars like this one to help nonprofits learn more about the technologies that can help them in their day-to-day work. For today's webinar, you can use the GoToWebinar panel on the right-hand side of your screen to change your audio settings, enter your questions, and chat with us. At the end of the webinar presentation, we will have a formal Q&A session where I'll ask questions to the speaker on your behalf. Just a reminder that you are on mute, so if you have any questions or concerns, feel free to chat to us in the question box. Also, you can download a copy of the presentation under Handouts in your control panel, and today's webinar recording will also be uploaded to our website. Now I'd like to hand things over to Louise Howes from Volunteer BC.
Hi, good morning everyone. My name is Louise Howes. I'm here on behalf of Volunteer BC to welcome you to the webinar. I'm having a little technical difficulty here. I'm not able to go forward with our slides. Oh, there we go. Sorry. So Volunteer BC, we're the provincial voice of volunteerism with the goal of promoting the value of volunteerism and building healthy BC communities. It is my pleasure to welcome you here today and to introduce our speaker. Manit Zemmel is a lawyer and co-founder of Zemmel Van Kampen, LLP, a technology law and litigation boutique law firm in Toronto. Ms. Zemmel has substantial experience and expertise in internet law, including Canada's anti-spam legislation, online defamation, and cyberbullying. Ms. Zemmel has also substantial experience in commercial litigation involving domestic and international disputes. Ms. Zemmel has advised multiple nonprofit organizations and charities on CASL compliance and has drafted their template compliance policies, including for large umbrella organizations. In addition to her law practice, Ms. Zemmel is a part-time member of the Ontario Landlord and Tenant Board, where she adjudicates disputes between residential landlords and tenants. Ms. Zemmel also teaches business law at the University of Toronto and Ryerson University. So without further ado, I'm going to pass along the presentation to Manit.
Thank you, Louise. Thank you, Ben, for the lovely introduction. Hello, everybody. It's nice to speak to a big group all over Canada out of my little office in Toronto, so welcome. I am going to dive right into it. I already got this very nice and I'm humbled by this, by the introduction. And again, I want to thank TechSoup and Volunteer BC for having me speak to you. This is the second time I've spoken about CASL this year. We had another seminar like this a couple months ago, and then I believe we had a couple more 3 years ago. So I always enjoy these webinars, particularly to the TechSoup community. So thanks and welcome. So what we're going to do is I'm going to basically go right into my presentation, and then as Ben mentioned, as we go along, you're welcome to write in your questions in the question box, and hopefully, and I'm saying hopefully because we do have a little time at the end for Q&A, I will be able to answer all your questions. I doubt it because we have over 1,000 attendees, and if each of you have a question, we'll be here pretty much for the next 2 weeks. But what I will say, and I have done this with the presentation I did a couple months ago as well, is at the end you'll have my contact information, and there will be circulated a sort of questionnaire sheet to find out if you want to sort of follow up with me. Happy to sort of set up some kind of consultations with you and help you out through your CASL compliance process. So, and again, any questions we don't get to, you can always send me and we'll talk about it. So, without further ado, let's talk about Canada's anti-spam legislation. Not the most exciting area to talk about, but something that you should all know and be aware of, which is why you're here. So, Canada's anti-spam legislation, or as we refer to it as CASL. Yeah, just before we go ahead, I'm going to put my little disclaimer here. I am a lawyer. We always have to have a disclaimer up front. So just so you should know that this is I'm not giving you any legal advice here. This is purely informational. But if you do want some advice specific to your organization, as I mentioned earlier, after any time in the future, you can contact me and we can do it. We can set that up. Okay, so here's what I'm going to talk about today. Basically, I'm going to cover the very general topic of CASL. Give you sort of a synopsis of what CASL is about, where is it at, where are we today 3 years after it has come into force. And then I'm going to spend a significant amount of time talking about commercial electronic messages, or CEMS, because really that is the bread and butter of CASL. That is the main area that it regulates. There are other areas that it regulates, but the CEMS is the main focus, and particularly what you guys are here to hear. Most of you are here to hear about. So we'll talk about that. And then I will spend some time talking about the various exemptions to CASL, but in particular, for lack of time, there's a whole host of exemptions. We are going to focus on the Charities exemption, which is intended for all registered charities in Canada. So I assume a good portion of you are registered charities, so we're going to talk about your exemption. And finally, I'll give you some tips, best practice recommendations to take with you after this presentation, things to think about, stuff you should consider doing. All right, so what is CASL? Well, I have this little cartoon there because I want to kind of send a message to all of you, and I want you sort of to think about CASL as not an anti-spam legislation, even though we refer to it as Canada's anti-spam legislation, and that is actually not its legal name. It has a long paragraph long name. CASL is its sort of synopsis, but it really is misleading because CASL actually doesn't regulate what you would traditionally consider to be spam. Okay, when we think of spam, we think of these emails from the prince in Nigeria asking you for some money, so maybe some emails trying to sell you something, some product that you've never heard of from, I don't know, wherever in the world, or maybe some emails that have a phishing link where your information is then the personal information is then stolen, or you get hacked, your computer gets hacked. So those are the traditional ways of what people think of when they think of spam. They also think of spam as an email that is sort of a mass email, right? You click send and it's sent to your entire contact list, or a huge portion of your contact list. Guess what? That is not what CASL regulates, none of it. What CASL regulates is commercial electronic messages sent or accessed from a computer in Canada. So not spam, but commercial electronic messages, or CEMs. Now there's other areas, sort of electronic activities that CASL regulates, and some of you might be engaged in it, so you should be aware of it. One of which is the installation of computer programs on your computer, misleading advertising and marketing practices online, privacy invasion through your computer, and the collection of email addresses without your consent, or email harvesting. I'm going to focus on CEMs in this presentation. I'm going to give you one slide at the end also about collecting email addresses without consent, because some of you might be doing that and without knowing that you are violating CASL. So I'll give you sort of a synopsis of that as well. All right, so what I tend to do to get your attention, because you're here for, some of you during lunch or morning break are here to sit on this presentation, but to make sure you stick around for the next hour and a half, I'm going to scare you a bit right now, okay? I'm going to scare you first, so therefore you know why you have to stick around for the next hour and a half and why you have to take this seriously. I'm going to start with enforcement. I'm going to start with the end. So before I'm going to talk about how you comply with CASL, I'm going to talk about what would happen if you don't comply with CASL. So CASL is enforced by three, not just one, but three government agencies, okay? first of all, it is the main government agency that regulates CASL is the CRTC. And the CRTC is tasked with regulating the part of CASL that deals with CEMS and the installation of computer programs. The Privacy Commissioner is also tasked with enforcing CASL, and the Privacy Commissioner focuses on the collection of personal information and address harvesting for your computer. And finally, the Competition Bureau also has some part of in enforcement of CASL, and it deals with misleading and advertising practices online. So basically, when you're talking about CASL, you're talking about being faced by 3 different government agencies and with different approaches to things. So you have to keep that in mind. And the other thing to keep in mind is that when the government said, when CASL came into force, the government made a point of making it as accessible as possible for anyone to complain to the regulatory bodies for violations of CASL. What do I mean by that? Well, if you think of different other forms of regulation, here in Ontario, maybe it's a Consumer Protection Act or whatever it is, and you want to complain. Often you got to go to some office somewhere that, you know, in some building somewhere, wherever it is, stand in line, wait in line, fill out a form, then you sign it. It's such a hassle. No, most people don't do it. Well, CASL is different. For CASL, the government has set up this website. All of you can go to it. It's called fightspam.gc.ca, and within a few clicks of the mouse, you start a complaint. So in other words, you're not happy about an email you get, you start a complaint, and next thing you know, there's a regulatory proceeding started against the person against whom the complaint was made. So just keep in mind, very easy to complain for violations of CASL. So here's the part where I scare you. Well, what happens if you won't comply with CASL? And this is why you're all here. Well, first of all, the government has made it very basically is sending a message to say to everybody, you got to take this very seriously. And they did this by imposing very significant administrative monetary penalties, or fines. Let's call them fines, okay, for violations of CASL. And CASL says that an individual, so just that's one person, an individual may be fined up to $1 million for each violation. That's just one email. And a corporation or organization, so a nonprofit organization would fall under that, can be fined up to $10 million for each violation. So very, very big numbers there. And what does it mean can be fined? It basically means that that's the highest number. But there's the range is huge, as you can imagine, and the CRTC that imposes these fines has a lot of latitude to decide what number to impose. Now, here's the good news. A couple months ago when I was giving this presentation, everybody was on the call because they were worried about July 1. And July 1, 2017 is important for CASL's for enforcement of CASL for 2 reasons. One of those reasons, what we call the private rights of action. So what does that mean? CASL says CASL is currently being enforced through regulation. In other words, if you violate it, someone would start a complaint against you with, let's say, the CRTC, and then at some point you'd be facing the government regulatory proceeding. In addition to that, in CASL, there is what we call the right of any individual, any person who is a recipient of an email in violation of CASL to sue you in court. It's called a private right of action. Go to court and sue you for violating CASL. And if you have one email sent to 1,000 people, well, then that's 1,000 people suing, and that turns into a class action. So big lawsuits are potential for big lawsuits. Now, when CASL came into force, which was back in July 1, 2014, the government had given some reprieve to companies, to organizations, to say, you know what, we're going to put off the private rights of actions until July 1, 2017. So until July 1, 2017, all you can face, it's still very serious. What you face if you violate CASL is a regulatory proceeding with fines before the CRTC. After July 1, 2017, guess what? Now you can also be sued, which of course brings the liability to a much higher level. The good news for all of you is as of about 10 days ago, or maybe 2 weeks ago, the government backed down, and they were under a lot of pressure from various lobbying organizations, and they removed the July 1, 2017 coming into force date for the private rights of actions. And basically they said at this time the private rights of actions are not going to be enforced until a date to be proclaimed. In other words, we have no idea when it's going to start. could be indefinite, who knows. But they basically removed that July 1, 2017 date they took it off the table. So in other words, right now, while there's a risk of a private rights of action, we don't know when those are going to start. So that's the good news as of 2 weeks ago. But what do you face in addition, what's in the meantime? Well, as I mentioned, you're facing regulatory proceedings before any of those three bodies I talked about, and up to the $1 million fines that I just mentioned. You also may be facing vicarious liability of organizations for its employees. So if you're a nonprofit organization, one of your employees commits a violation of CASL, sends an email not in accordance with CASL, the organization itself can be held liable for that non-compliance. Furthermore, there is also liability, personal liability of officers and directors for acts of the organization. So again, organization sends out an email in violation of CASL. It's officers, it's ECs, it's executive directors, it's board of directors, it's executive officers. All of those individuals may face personal liability. Not a good thing for them. And finally, in addition to that, the CASL gives these government organizations, those three government bodies I mentioned, sweeping investigative powers. Basically, they can go in, they can search stuff, they can look for evidence to support their the complaint. So those are the various significant consequences you can face for noncompliance, and I hope I scared you enough to get your attention. So now, let's talk about what has happened so far in terms of enforcement. You know, we're now up to the 3-year mark since CASL came into force, and there have been not that many publicly available public information regarding how the government has been enforcing CASL. Whatever we know is basically on this slide, and it's limited. And what I mean by that is it doesn't mean that there aren't other numbers and other people, other companies that have faced, other organizations that have faced these kind of fines. It's just these are the ones that were made public. So, because a lot of the stuff is done not done publicly. But what we do know is, so if you see, this is actually an old slide. I wrote as of February 2016, so this is over a year ago, we knew that there was over 500,000 complaints filed with the CRTC about CASL. What I could tell you now, and this is, I should update that because I attended a webinar with representatives of the CRTC a few weeks ago, and they have said that they're up to 1 million now. So there's about 1 million complaints that these guys are sifting through. Now, how much resources does the CRTC have to sift through 1 million complaints? Who knows? But you can imagine it's taking a while. So over 1 million complaints in 3 years. What we do have in terms of tribunal decisions. So the CRTC has two parts to it. It's a body divided into two sections. One is the enforcement section that basically is the prosecutorial part of it, and then there's the tribunal. It's a sort of like it's an administrative tribunal that is intended to hear the regulatory proceedings, consider the regulatory proceedings. And thus far, we have 2 reported decisions of the CRTC tribunal. The first one is against an individual. It's the only one we have against an individual as opposed to an organization or a corporation, by this guy by the name of William Rapinos. And he was facing a fine of $15,000 for violating CASL, some emails he sent out. He challenged this before the tribunal. The tribunal said, no, sorry, you did what you did wrong, you're going to pay $15,000. Another tribunal decision which was relatively positive for the person who was the company that was facing it, Blackstone. So Blackstone was a company, again, facing violations under CASL. The CRTC prosecutorial body was seeking a fine of $640,000. Remember, they have up to 10 million, so they chose 640. Blackstone fought that before the tribunal, and the tribunal reduced the amount to 50,000. So a big difference. They took it down to 50,000. We also know that there is currently an ongoing proceeding, which we don't know much about, other than there has been a notice filed against them, against a company called CompuFinder out of Quebec, and they're facing a fine of $1.1 million for violating CASL, and they're fighting it right now. We don't know what the status is, but what I hear from the CRTC is that very soon we will have a decision on that, publicly made, about what they're going to do, whether or not by the tribunal or by the CRTC. So they're facing the $1.1 million, they're fighting it, we'll see what happens. And then we've got undertakings. So what are undertakings? Undertakings are basically a way in which a company can say, a company organization can say, you know what, we made a mistake, we violated CASL, we'll pay a fine, we'll agree to do better. And if once you sign this, and we're going to agree to do this, and make it public, so therefore from now on we don't have to face any more regulatory proceedings. It's like a settlement, a plea bargain in the criminal world. So we know of 4 undertakings that were made public. And those, sorry, I'm sorry to cut up for a second. Louise or Ben, can you hear me okay? Because I'm getting a little note on my screen here that there may be some connection difficulties on my end. Can you hear me okay?
We can hear you fine, Manit, but we do have feedback from many attendees who ask you to speak a bit slower.
Oh, I'm so sorry. Yeah, and I'm only speaking fast because I have a lot to cover. I usually talk slower, so I'm sorry. I'm trying to cover a lot in a short amount of time. I will slow it down. And actually, the reason I'm going fast through this is because this is the background. I will slow down on the important parts, I promise. But because I know how much time this takes, I'm rushing through this, and I'm sorry. Okay, so very quickly, here are the 4 companies we know that have faced or have agreed to undertakings. Kellogg's Canada had paid a $60,000 undertaking fine. Rogers paid $200,000. Porter Airlines $150,000, and Plenty of Fish, that's a dating website, they paid $48,000. So big numbers there. Not so big for Rogers or Porter Airlines, but huge numbers for nonprofits and charities. I can also tell you that I don't know of any as of today, I am not aware of any nonprofit organization or charity that has been facing any form of regulatory proceeding before the CRTC. I am not saying there haven't been complaints filed. I just don't know of anyone that that the CRTC has taken on. I asked the CRTC when I went to this webinar put on by the CRTC a couple of weeks ago for lawyers. I specifically asked their reps. I said, do you know what percentage of that 1 million complaints was against nonprofits and charities? And they just looked at me blankly and they had no idea. So I don't know. They don't keep track of this information. The answer I got is we have no idea. So, but they seem to suggest that there's nothing going on in terms of an actual proceeding against a nonprofit or a charity. Not that I'm aware of anyway. So now that I've scared you, here's the good news. I always like to go from bad news to good news, so this is the really good news. What can you do, and I'm going to say this right up front, what can you do to defend yourself if you are faced with a complaint for violating CASL? Well, guess what? There is a very important defense in CASL called the Due Diligence Defence. And basically, very simply, what it says is that if you can show as an organization that you have developed and implemented a comprehensive and effective CASL compliance policy, similar to a privacy policy, similar to any other type of policy you have. I'm sure some of you will have harassment and non-discrimination and harassment policies, all kinds of social media use policy, whatever it is. So certainly, I always compare it to privacy policies because they're very similar. If you have that and you put it into place and you implement it, then you have a complete and absolute defense to CASL. So in other words, as an example, if you put this policy into place, you implemented it, you trained your employees, they know about it, and something goes wrong and there's a mistake. Someone sends an email out in violation of CASL. You end up with a complaint against you, the CRTC picks it up, they're knocking on your door, you say, hey, I've got this policy, look, I've trained my employees, this was a one-off thing, it won't happen again. The CASL gives you that defense, and the CRTC would often just back off. So that is why it's so important, and at the end of this presentation, I'm going to give you some tips about how to put together a policy, because that is really your best defense, always. Best defense, have a good compliance policy. So that's my intro on CASL. And now that I have your attention, I hope, let's talk about the meat of it, and what I mentioned earlier, which is the CEMs, or Commercial Electronic Messages. So what is a CEM? A CEM is a message, and this is me paraphrasing the definition. So a CEM is a message sent by any electronic means. So it could be email, text, instant message, tweet. It doesn't have to be just email. Okay, so it applies to text just as much as it applies to emails. And that has, as its purpose, again, this is the CASL's words, as its purpose or one of its purposes to encourage participation in a commercial activity. So very, very broad definition, okay? And you'll notice what's not in there. It doesn't say a message to more than one or more people. What does that mean? It means a CEM covers an email to one person. That's just as good, the same as sending an email to 1,000. So it's not about how many people get it. It's about what is in that message. So let's talk about the definition of commercial activity, because that is really the meat of the definition of CM. And that is also very broadly defined in CASL. And again, I'm paraphrasing the definition because it's very long, but the main important part of it is where it says that it is at any particular transaction, act, or conduct that is of a commercial character, whether, and this is the key, whether or not the person who carries it out does so in the expectation of profit. And why do I say that is key, and why do I highlight that part? Because those words were included specifically and intentionally by the government to say this applies to emails sent by nonprofits and charities. Pretty much. That essentially is what says a CEM is sent by nonprofits and charities. So here's some points about the CEM definition. Like I said earlier, the definition of commercial activity is very, very broad. It applies to any transaction, act, or conduct, which means that a commercial activity doesn't mean that there has to be an exchange of some form, okay, for it to be a commercial activity. Anything that you do that is commercial in nature, okay, would be considered commercial activity. And it applies to nonprofit activities, and it applies to charitable funds. That we know for sure. So here's the big question. Do charities and nonprofits transmit CEMs? The answer is absolutely yes. And here's some examples. And this is based not just on my interpretation, but also on what the CRTC has said. Okay. First of all, any email seeking donations is a CEM. That is, there's no question about that, because you're essentially asking for, you're engaged, asking for commercial activity, but there's no profit in it. Okay. Email selling tickets to an event or a lottery are also CEMs. Emails promoting the services of a nonprofit, if the services have some kind of a commercial nature to them, okay, commercial character to them. Emails promoting a charitable event or activity, emails promoting the organization, the charity, if the organization or the charity is involved in anything that is commercial in nature, which most of you are in some form or another. E-newsletters, those are CEMs, and I'll talk about those in particular and why those matter, but not all of them. Let me put it, not all e-newsletters are CEMs, but some are. So for example, when are e-newsletters not CEMs? They probably won't if they, and you know, as long as they don't encourage participation in a commercial activity, they won't be. So the most, the best example would be a newsletter that is educational entirely. There is nothing in it that promotes the organization, nothing in it that promotes some kind of an event, nothing in it that is asking for donations. It's purely just, here's a newsletter about this particular treatment for whatever it is. I don't know what it is. So if it's purely educational, it may not be a CEM, okay? A sec. Oops, wrong. There we go. So now that you know that you send CEMs, well, what are the requirements? What do you have to do to comply with CASL? Well, there are 3 general requirements for compliance with CASL for any CEM sent by an organization. First of all, you can't send that CEM. You just can't, unless 3 things happen. First of all, the receiver has already consented to receipt of the CEM. In other words, you have got consent before you press send, or not, because this is an opt-in regime. Okay, so you have to look at the recipient and say, hey, have you opted in to receive CEMs from me? Great, I'll click send. Okay. 2, the CEM contains certain prescribed information. I'm going to talk about that in a few minutes. I'm going to break all these down, by the way. So don't just, you know, it's coming up. And finally, number 3, the CEM contains an unsubscribe mechanism. Again, I will break that down for you. So let's first talk about the most important part of the requirements regarding CEMs, and that's the consent requirements. Here's the key. CEMs may only be sent with the recipient's express or implied consent. So there's got to be consent first. And the onus of proving you have consent will rest on the sender. So you have to make sure that you have consent. And if you're faced with a complaint, it's up to you to prove that you do. Okay, it's not up to the receiver to say, well, I never consented. They don't have to prove that. They just have to say, I didn't consent, and then you have to prove that they did. Okay, and an electronic, here's another key, an electronic message requesting consent is a CEM and is therefore prohibited. What does that mean? You cannot send an email out to say, hey, could you give me consent to send you emails? That's pretty much what it means. The only time you can do that is if you already have consent. And we'll talk about how you get to that. If you have, for example, implied consent, you can then send an email to say, hey, give us consent to going forward in the future for everything else. But you cannot, the bottom line is you cannot just say, oh, why don't we just send and ask for everybody for consent? You can't do that because CASL said you just can't. So remember I said there are two kinds of consent. There's express consent and implied consent. I'm going to break that down and talk about express consent first. What is express consent? Express consent is basically someone saying to you, I want to receive electronic messages from you, commercial electronic messages from you. Okay, I give you my consent. Now, that consent can be in oral or it could be in writing. Now, as a lawyer, I always tell clients, much better to get it in writing because it's going to be much harder for you to prove later on that it was when it was given orally. But the law says it's okay to get it orally. And for example, you can get it by calling someone and asking them over the phone, right? And there are specific requirements that the CASL said as to what has to be included in the request for consent. Okay, so for example, and I don't get into those too much in detail because I just don't have the time. But there are a few things you've got to do. You have to make sure that the recipient understands what they're consenting to. So you can make it convoluted. You know, using legalese is usually bad. Make it very clear, very simple. You have to tell them when they're consenting that they can change their mind at any time. They can unsubscribe at any time. Okay, so that's one of the requirements. So that's express consent. Now, the other thing about express consent, and it's not in this slide, and it should say, is that express consent is indefinite until someone unsubscribes. So in other words, once someone says, yes, I want to receive CEMs from you, guess what? That's pretty much, there's no timeline to that. That just goes on, you know, to the end of time, indefinitely. Unless someone says, okay, I take back my consent, right? As long as they don't unsubscribe, you've got express consent, you're good to send, and you can send whenever. But implied consent is a bit different. So you remember there's express consent or there's implied consent. So for implied consent, there are various ways. Oh, I feel like I'm missing a slide here. Just a second. It may have been. Just a sec. My apologies. Okay. Yes. All right. All right. So, Ben, I'm sorry, but for whatever reason, a couple of slides have dropped. What I'm going to do is I'm going to give an updated slide presentation to TechSoup. I'm really sorry for this. I don't know why. I noticed I'm missing a couple of slides, and so the new updated slide will be online if that's okay with you, Ben. So I'll give you orally what the other slides say. So the couple of slides before this one talk about implied consent in general. And basically, there's what I would call two kinds of implied consent. There's indefinite implied consent, and then there's definite implied consent. What is indefinite implied consent? Indefinite implied consent is exactly how I termed it. It's implied consent where, by virtue of the type of the circumstances of this particular case or particular situation, you have implied consent to send CEMs to this recipient, and there's no timeline on it. And so I'm just going to go back to this for a minute. And so what is the indefinite implied consent? Well, implied consent under CASL from an indefinite that is indefinite is based on two types of circumstances. The first one I would refer to as the publicly available or public disclosure implied consent. What does that mean? It applies to a situation where the recipient, the person who you're sending the CEM to, the electronic message to, has conspicuously, that's the words, conspicuously published their email address or their electronic address. Okay, so it could be their phone number for if you're sending a text as well. But let's stick to email, for example. So they conspicuously publish their email address. Okay, what is conspicuously published? They put it on their website, for example. Okay, so it's online. You can find it anywhere. It's not hidden. It's right there. And next to that email address, it doesn't say, don't send me CEM. So in other words, kind of think of it like when you're at, some people at their house, on their mailbox, there's a sign that says, I don't want any junk mail. So the same idea is for this particular electronic messages. So in other words, this person has a website. On their website, it says, here's my email address. And nothing in the website says, don't send me electronic messages. Okay? And the third part to that, though, there's another very important requirement. The recipient of that electronic message, my apologies, the content of the electronic message has to be relevant to the recipient's business role in a particular organization. So, for example, all right, I am a lawyer. I have a website. On my website, you'll see my email address. On my website, it doesn't say, please don't send me CEMs. So I met the first two requirements. However, do you have implied consent to send me CEMs? No. You only have implied consent to send me CEMs that would be relevant to my job as a lawyer. Okay? So if, for example, you're selling some kind of service to lawyers, guess what? You have implied consent to send me CEMs. But if you're going to send me some kind of email promoting your organization that has nothing to do with being a lawyer, or asking for donations, etc., to your organization, again, that is not necessarily focused on legal services, then you don't have consent, implied consent. So that's the idea. It has to be relevant to the recipient's role in the business, the organization, etc. So that's the first part of the indefinite implied consent. The other type of indefinite implied consent, which is similar to what I just described, but the only difference would be is that instead of it being the email address being conspicuously published, let's say online, the person to whom you're sending the CEM had disclosed their electronic message, their electronic address to you. So I call this the business card implied consent. What does that mean? For example, you met someone at an event, they gave you their business card. On the business card is their email address. Guess what? Now, under the indefinite implied consent requirements, you have implied consent to send them CEMs to that electronic address on their business card because they disclosed it to you. They gave you their business card. They gave you their email address. But going back to how, as I said earlier, it's similar to the other type of implied consent. The content of that email has to be relevant to the recipient's business role or model. So again, let's go to an example. I'm talking about myself because as an example, I met you at an event. I gave you my business card. Great, you have implied consent to send me electronic messages, but like before, it must only be relevant to my job as a lawyer. If it's not, it goes beyond what is relevant to my job as a lawyer, can't send me, I don't have implied consent. You don't have implied consent to send me CEM. So that's the idea. So indefinite implied consent would apply to people who have somehow published their electronic address to you. Either they gave it to you personally or they put it online. They made it public, and the content of the message is relevant to their business or their role in the organization. So that's indefinite implied consent. And again, I had a couple slides about that. I will again update this slide deck, and I will include those slides. Somehow in the emailing, and they may have dropped out. My apologies. So now let's go to the definite implied consent, the ones where there's a time limitation on them. Okay, so the ones I talked about earlier, the indefinite implied consent, mean that the implied consent lasts as long as the person has conspicuously published their website. So as long as their email's on the web, it's fine. There's no time limitation. There are other types of implied consent that have a time limitation associated with them. And the first one, and the most common one that nonprofits rely on, nonprofits and charities, is what we call the non-business relationship. What is that? Basically, CASL says that you have implied consent to send CEMs if you are a registered charity, which is defined under the Income Tax Act, and your recipient of those CEMs has made, as a donor, a past donor, has made a donation to you or performed volunteer service for you in the 2 years before you sent that CEM. So in other words, just let's flip it around. From the moment someone donates to you or the moment someone volunteers for you, if you're a registered charity, you have 2 years from that moment going forward, implied consent to send them electronic messages. But the clock is ticking for 2 years, okay? And every time someone volunteers again or someone donates again, that 2-year period starts again. So good news if you're a registered charity, right? For nonprofit organizations that are not registered charities, or that they are, but the bottom line, there's one additional type of non-business relationship, and that some of you would rely on very heavily, and that is the membership relationship. So CASL says that you have 2 years implied consent to send CEMs to anyone who has been a member of yours in the 2 years before you send the electronic message. What do I mean? Make it clearer. Oh, I'm going to flip it around. I'm going to say that 2 years begins to run the moment membership ends. So as long as someone is your member of your nonprofit organization, you have implied consent to send them CEMs. No problem. And that implied consent continues for 2 years after they are no longer a member. So let's say they have a 2-year membership for whatever reason, they don't, or an annual membership, and they don't renew it. So from the moment their membership ends, you can still send CEMs for 2 more years. You can ask them to maybe renew their membership for 2 years. Okay, so that's basically the 2-year implied consent or not for non-business relationships. And so here's some notes about those. Basically, this summarizes what I just said. So first of all, you've got a 2-year period for donors and volunteers. Begins to run at the date the last donation or volunteering happened. The 2-year period of implied consent for members begins to run when the membership is terminated. And here you can see there are other prescribed circumstances for implied consent, existing business relationship, conspicuous publication. So as you will see, there are other stuff, and I realized it wasn't a mistake. I just took those slides out because I didn't think I'd have the time to talk about them. But I figured I'll tell you about them anyway, and I will give you those slides. So if you notice, I mentioned here there are other prescribed circumstances for implied consent. The one other type of implied consent that you might rely on is called the existing business relationship. Again, I have a slide on that, and I will include that in my updated deck. An existing business relationship is one where there is an exchange of value between yourself and the recipient of the email. So there's some kind of an exchange of value that you sold them a product, you sold them a service, whatever it is they paid for. It can't be for free, okay? So there has to be an exchange of value. And you give them the services for it could be a barter, whatever it is. There has been an exchange. Maybe you entered into a contract with them. From that moment forward, you have 2 years from the moment you have that exchange, and 2 years thereafter, you have implied consent to send them CEM. So again, as soon as you have an exchange of value, you get 2 years implied consent. And that's called an existing business relationship. So here are some warnings about implied consent. First of all, keep in mind, as I mentioned earlier, most of these implied consents, not all of them, most of them have a 2-year limitation period on them. So you got to watch out for that time limit. You have to keep track of it, okay? And even though you have implied consent, you have to still comply. You don't even have to get express consent. You still have to comply with the other 2 requirements of CASL, which is prescribed information and unsubscribed mechanism. I'll talk about those in a few minutes. And an implied consent can always be withdrawn, taken away by an unsubscribe. So in other words, let's say someone is your member. You have implied consent to send them CEMs. All good and fine. You're sending them electronic messages, no problem. And then they unsubscribe. Even though they continue to be your member, because they unsubscribe, you have to take them off the list. You can no longer send them CEMs because any implied consent ends when someone unsubscribes. And as I said, you have to implement those requests to unsubscribe. Now, one more point about implied consent, and this is where the July 1, 2017 date comes in, all right? We took away that part about private rights of actions because those were taken away by the government, but there's still one important part to CASL regarding July 1, 2017, and that is what we call the transition period. So when the Act came into force back in July 1, 2014, okay, the government said, okay, we'll give you a little bit of time, organization, this is mostly for I'm talking for the nonprofits and the charities, we'll give you some time to comply, to gather your express consent. We're going to give you 3 years, and how we're going to do that is we're going to say that 2-year implied consent we talked about earlier, right? We're going to extend that all the way to July 1, 2017 for anyone who met that relationship, was part of that relationship, was either a donor, volunteer, or member before July 1, 2014. We're going to give you some extra time. But guess what? We're now at June 22nd. We're only 8 days away, okay? So 9 days away, I guess. So coming up, what does that mean essentially? Anytime, any person who was your volunteer, if you're a charity, if you're, for example, a registered charity, anyone who donated to you or volunteered for you before July 1, 2014, okay, you have 11 more days of implied consent from them, okay? Nonprofit organizations, anyone who was a member of yours before July 1, 2014, but ceased to be a member before July 1, 2014. So let's say you can go back like 20 years, it doesn't matter. Someone who was a member of yours 20 years ago, though I doubt you'll have their email address, because how many people had email addresses 20 years ago? But so let's be more realistic. Let's talk about July. Let's say someone who was a member of yours and their membership expired in January 2010, okay? So you haven't heard from them. You've been sending them emails, but they haven't really renewed their membership. You have implied consent to send them CEMS until July 1, 2017. So you have 11 more days to contact them. And if they don't give you express consent in 11 more days, you take them off the list, because you no longer have implied consent, and you should not be sending them any electronic messages if you're a nonprofit. Okay, so that's sort of how the transition period worked. All right, so that's implied consent and express consent. Right, so that's basically your the first and most important part of CASL's requirements. The second requirement that you have to apply to each and every CEM that is not exempt under the Act, and we'll talk about exemptions later, but in any event, these are the basic requirements. You have to include in all CEMs the name, the mailing address, and either an email address, a telephone number, or your website. So notice there has to be a mailing address. Now, most of you probably already have that in your signatures, but if you don't, you should make sure you do. Okay, so every electronic message should have that. There has to be a means by which to contact the sender that's effective for 60 days. So in other words, what that is intended for is, like, don't have an email in there that's like, if someone sends you an email 10 days later, it doesn't work anymore. It's got to be working for the next 60 days. And again, in each and every email, there has to be an unsubscribe mechanism, and we're going to give you some details about that in a minute. Now, let's say you're sending out, like, remember how I said CEMs can also include text, right? So let's say you decide to send something, do a campaign using text, okay? You don't want to include all this information in a text. It's ridiculous, right? So what the CASL says, okay, fine. If it's not practical for you to include all this stuff in the CEM, you can just have a link in it, that hyperlink in the text, for example, that then when they click on it on their smartphone, it will take them to your website with all that information. Okay, so you can do that, for example. But in any event, that link has to be prominently and clearly set out in the and readily accessible. So that's the prescribed information. Let's talk about the unsubscribe. The unsubscribe is a very important part of CASL. I can't stress it enough. A few reasons. First of all, you saw some of those companies that were that got dinged, I'll call it, by the CRTC for violating CASL. Often it was because they didn't do a good job with the unsubscribe. So you know, the CRTC, I know, is not happy when people don't take the unsubscribe seriously, and that's the first sort of more general reason why it's important. The other reason why I say, from a practical perspective, it's important is because when someone unsubscribes, when someone tells you, I don't want to hear from you, and you still go ahead and send them electronic messages, I guarantee that the chances of that person complaining about you are much higher than anyone who hasn't unsubscribed, okay? Because they have told you they don't want to hear from you, and so if you still continue sending them electronic messages, they're likely to complain. So take the unsubscribe very seriously when you think about your risk assessment and how much you want to, to what extent you're going to comply. So here's what you need to know about the unsubscribe mechanism under CASL. First of all, as I said, every CEM has to have one in it. It has to be done by electronic means. In other words, you can't have it say, to unsubscribe, please print this, sign, and send it to us by mail. The CASL requires the unsubscribe mechanism to be electronic. Okay, so So it could be, for example, a link, you click on here to unsubscribe, and then they click off whatever they need to say. We don't want to hear this, we don't want to get this, whatever. Or if you don't want to spend the money in doing that, you want to make it as simple as what I do, for example. In the bottom of each email, CM I send out, there's a line that says, if you want to unsubscribe to receive CM from my law firm, you send an email to this electronic address with the word unsubscribe in the subject matter. And that's all they need to do. Okay, it's still electronic means, it's easy, it's simple. Okay, so you can do that, but it has to be electronic. Second of all, it has to be effective for 60 days. What does that mean? It means that if someone wants to go back in the next 60 days to your email and unsubscribe through that link, you have to make it available to them for that 60 days. So in other words, they'll get your email. They're not sure if they want to unsubscribe, but then like 30 days later, they're like, you know what, we don't really want to hear from that organization anymore. That way we don't like them for whatever reason. I want to go and unsubscribe. They can go back to their old email from 30 days ago and unsubscribe. Second, and very important, you must give effect to any request to unsubscribe within 10 days of the request. Okay, so someone unsubscribes, you got 10 days to take them off your list. Now, my suggestion is do it sooner than 10 days because, again, it's just if someone unsubscribes and then 2 days later you send them an email, they're not going to be very happy. So to avoid risk, just do it as fast as you can. But certainly, legally, you have to do it within 10 days. And you can't charge them for unsubscribing, okay? Or you can't penalize them for unsubscribing. Oh, if you unsubscribe, we will no longer provide you services. No, you can't do that, okay? So that's all in terms of the CEM requirements, all right? We've got 3 requirements: consent, unsubscribe mechanism, and prescribed information. Okay, so those are what the CASL requires for all CEMs, unless CASL says that the particular CEMs that you are sending are exempt from compliance with the CEM requirements. And what CASL has done is that it created 2 types of exemptions. The first one is what I would call a complete exemption. It basically means that if you meet the specific requirements of these exemptions, you don't have to worry about any of those requirements. You don't have to worry about consent. You don't have to worry about prescribed information. You don't have to worry about unsubscribe. It doesn't even matter if they unsubscribe. You can still send them CEMs because they fall under a complete exemption to CASL. Then there's the partial exemptions. The partial exemptions are the ones that say you don't have to get consent. You're exempt from getting consent, but you still have to include the prescribed information and you still have to allow them to unsubscribe, okay? Now, it's on you to prove that you meet one of these exemptions. So you need to make sure that you keep good records of whatever it is you're relying on in order to prove that you are exempt from complying with CASL. Now, as you can see, due to time constraints, I will only be covering what is most pressing for some of you who are registered charities, which is the registered charity exemption. However, after I talk about the registered charities exemption, I have a couple of slides where I list all the other exemptions. Well, you can read them, you can maybe look at them, and if you want, we can later on, you can contact me and we can talk about those exemptions. But registered charity exemption is the one that's intended for registered charities, and we're going to focus on it today, okay? So this is the exemption that was lobbied for by the charity community before CASL came into force, and they were able to get the government to agree to it. So good news, really good news for all of you registered charities. Those of you who are not registered charities under the Income Tax Act, this does not apply to you. Okay, so nonprofit organizations that are not registered charities cannot use this exemption. Okay, so what is it? Well, basically what CASL says is CEMs sent by or on behalf of a registered charity are exempt if the message in that CEM has as its primary purpose raising funds for the charity. Okay, so as long as the primary purpose of your message, of your CEM, is to raise funds for the charity, you are exempt from complying with CASL's requirement. In other words, you don't have to get consent, you don't have to include that prescribed information in the body of the email, and you don't have to worry about the unsubscribe. If they unsubscribe, you can still send it. Okay? So here are some things you need to keep in mind for the registered charity exemption. First of all, as I mentioned earlier, you have to be a registered charity under the Income Tax Act. Okay, and if you're not sure, I've had some clients that I've consulted with, and they say, well, we don't know if we're a registered charity. I tell them, call your accountant. They will know. Okay, so if you don't know, call your accountants. And here's what it's so important, and this is a mistake that a lot of charities make, okay? When CASL came into force, I have a lot of charities call me and say, well, we didn't even bother considering CASL because we heard we're exempt, we're a charity, we don't have to comply. That is not correct, okay? You have to comply with CASL for all CEMs that are not sent for the primary purpose of raising funds for the charity. If the CEM doesn't meet that test, the primary purpose test I call it, it is not exempt. So it really depends on the content of that CEM that you're sending out. You have to give it some thought. You have to make sure that it's for the primary purpose of raising funds. Now, talking about raising funds, I'll talk about primary purpose in a minute. What does that mean? But first, let's talk about raising funds. So according to Industry Canada, this is what they say. They say that the words raising funds in CASL should be construed, interpreted broadly, much broader than the word fundraising, which is the words that are used in the Income Tax Act, for example. So that can include sale of tickets and services, let's say tickets to galas, charitable events, providing charitable services, that kind of stuff. As long as the funds are intended for the charity and not another recipient. Okay, so make sure, again, if you're raising funds for the charity, but you're raising funds, but actually the funds are going somewhere else, then it doesn't meet the primary purpose test. Okay. Now, let's go on and talk about those words. What does the primary purpose mean? When is the CEM, the content of the CEM for the primary purpose of raising funds for the charity? Well, the truth is we don't know because we haven't had any test cases. You know, as I mentioned earlier, there has been no decisions regarding charities, no public decisions, so we don't know. All we can go by right now is I go by two things. First of all, my own interpretation of the Act, the wording of the Act, okay, and what the CRTC is telling us, because they are the main body right now who deals with CASL. And according to their staff, and again, that doesn't mean that a court will follow this, but that's what the staff of the CRTC says. This is how they interpret it, okay? They say the primary purpose of a CEM means the main reason or the main purpose of the CEM. There could be a secondary or additional purpose to the message, but the principal purpose, you can notice it's very circular, right? But the principal purpose of the CEM must be to raise funds for the charity. So basically it's got to be, there could be other purposes. You could be talking about other stuff, but the ask has got to be up there. Okay, you've got to be asking for money somehow. It's got to be clear that that's the purpose of your email. You're asking for donations. You're asking for money. Okay, and the other part that the CRTC says, and I like this, I think this is very helpful for charities. It says that given that legitimate messages sent by registered charities raising funds are exempt under the Act, the CRTC will focus on messages sent by those attempting to circumvent the rules under the guise of registered charity. In other words, what they're saying is if you're a legitimate charity and your emails that you're sending out are legitimately intended for the purpose of raising funds, you're good. You don't have to comply. The CEMs, as long as the CEMs have, you know, the primary purpose, it's clear that you're raising funds, it's good. But if you're using your status as a registered charity to do other things, to send other stuff, to promote services of or products of other parties, or you're promoting something else that's not necessarily to raise funds for the charity, then guess what? That would not, the CRTC will focus on those and probably consider those not to be exempt. I can give you an example, and I get this question often. You know, sometimes I get questions from registered charities that they are, you know, they have it's very common, they have some kind of an arrangement with a business where if a person buys a product from this business, the business will donate $5 to the charity. Great promotion, good campaign, excellent thing. So the question I always get is, what if we send an email, we the registered charity send an email to all our contacts saying, hey, buy you know, sneakers from this company because every time you buy it, the company will donate $5 to our charity. Right? That's very common and that's completely fine. The question I get is, well, is that exempt? The answer is, I think that is gray. I'm not sure that would be held, based on what the CRTC has said, to be the primary purpose of raising funds for the charity. It could be argued that it does, and I certainly would argue on behalf of the charity if the charity is facing a complaint, to say, well, hold on, the only reason we're sending, the primary purpose of sending this email is because we want to raise funds for the charity. We don't care whether or not they buy you know, we're not trying to promote the product, we're trying to promote our charity and the money that's going to the charity. But really, you're also promoting someone else's product, right? So that's where gray area comes in, and that's what the emails where I say to clients, you know, I wouldn't rely on the exemption for these emails because they're the gray, they're iffy. Okay, so that's an example. Another example is when you are sending an email and you're promoting something else. I don't know, maybe I don't know what it is. Not something non-charitable, not or something to do with some charitable event, maybe not of your organization. Okay, so you're promoting something else, and somewhere at the bottom in a tiny little link it says click here to donate to us, and it's hidden. Okay, you know, I don't know if that's a primary purpose of raising funds because it's really hidden. You need to put the ask, make it clear that you're asking for a donation. It's clear that that's the reason why you're sending it. If you do that, you're exempt. You don't have to worry about the consent requirements or any of the other requirements. Okay. Now, here's another thing about e-newsletters that the CRTC has said, because I would say most of you, if not all of you, send e-newsletters, right? And you would be concerned about this. And this is what you should feel comfortable about, okay? According to the CRTC, if your e-newsletter contains a request for donations, all right? And on the site somewhere on the bottom, you have a logo of a corporate sponsor. That's okay. According to the CRTC, that is still, in their mind, you sending something for the primary purpose of raising funds for the charity. However, if you use it, again, like I said before, if you use your e-newsletter to promote or advertise a commercial activity that's not of the charity, for example, you're talking about your corporate sponsor, saying, hey, you should check out their website, they do great stuff, blah, 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 then you're again in the gray area and you likely are not exempt. Okay, so keep that in mind as an example for your newsletters if you're putting something together. So here's my warning for the charities exemption. It is questionable whether the primary purpose test will be interpreted and applied the same as the CRTC by a court in a civil action. So what do I mean by that? You know, in this slide, the CRTC is saying, hey, we're going to lay off the charities. We're going to be pretty lenient on you, and we're going to, you know, as long as you're promoting the charity or the charitable organization or raising funds, we're going to be okay. You're going to be okay, right? But that's the CRTC. We don't know what the court's going to do. We really don't, because we haven't had a test case. So keep that in mind. There is no guarantee that how the CRTC is interpreting the primary purpose test would be interpreted also by a court. So that's always something to think about. And the other thing that I'm concerned about, and I tell this to the clients, I think, and my view is, and this is just my opinion, it doesn't necessarily going to be correct because we don't know what's going to happen, how the courts are going to interpret this. But I suspect that the court may interpret the legislation from the point of view of the receiver of the email and not the sender, because at the end of the day, CASL is intended, the purpose of CASL is to protect the recipient against spam, unwanted email, unwanted email, okay? So in other words, the court may say, you know what, you charity are saying that you're sending this for the primary purpose of raising funds for the charity, but as a recipient, I'm looking at this and thinking, I don't see any ask here. I don't know why, I can't get from this that you're asking for funds. You're doing something else. So keep that in mind, okay? When you're thinking about how you're going to, if you're going to rely on the charities exemption, and you should consider definitely relying on it, how you're going to word the content of that email that you're sending out, okay? So here's a best practice recommendation regarding the charities exemption. I first of all recommend to charities do not exclusively rely on this exemption. Use the exemption, rely on it, but not exclusively. What does that mean? It means that you should consider developing and implementing a consent-based policy. In other words, we'll rely on consent, but for certain emails that we are, whether maybe it's a campaign or emails that we work on where we're sending out a blast and asking for money or selling tickets to a charitable event, at that point we're going to rely on those. We're going to rely on the exemption because we know that the wording is very clear that they meet the primary purpose test. But for everything else on our sort of regular emails we send out on a regular basis, you may want to consider relying on the consent, on getting consent. Okay, that's just a suggestion. You don't have to take it. It's a best practice. And here's the other thing. If you do choose to rely on the exemption, make sure, of course, that you do so only for the CEMS that are for the primary purpose of raising funds for the charity, and designate someone, a qualified person. It doesn't have to be legal counsel. I said legal counsel because some big organizations have legal counsel, but you don't have to. A compliance officer. It could just be your communications person, whoever it is, your ED, whatever it is, to vet the content of the CEMS, to say, okay, we're going to be sending out a blast to all these people, and we're just sending it to everybody because we want to rely on the exemption. We're not going to worry about consent because we want to get as many people we want to access as many people as possible. Fine. let's look at the wording of this email. Don't leave it to just anyone. Let's think about whether or not it's clear that the email is sent for the primary purpose of raising funds for the charity. And that way we know that we are in the clear. So that's the charities exemption. As I mentioned earlier, for lack of time, because I want to leave time for questions, here are the other exemptions, and I just list them, okay? So you can look at them later on when you download the thing. So there's another 14 complete exemptions in addition to the charities exemption, and there's 6 partial exemptions where you don't have to get consent. So you can consider them and see if they apply to you. So now let's talk about, I'm going to spend a couple minutes talking about the best practices, some things you should take away from this, okay? First of all, get your board on board. What do I mean by that? Decision regarding CASL compliance should form part of the organization's overall risk management strategy, okay? It should not just be left to your communications person on the ground who has to decide who to send what to. Okay, there needs to be a buy-in from management, whether it's your executive or even your board of directors, because at the end of the day, it's all about risk management. How far are we going to go to comply with CASL? Are we going to comply completely? Are we going to put a policy into place like we should? I mean, I recommend that you do. How much cost are we going to incur to do it? I mean, all depends, of course, on the size of the organization and the type of communications you engage in. But certainly the decisions need to be made at that level, because the board or the executive have to say, okay, well, you know what, we're going to take a chance, or we're not going to take a chance. If we are, how are we going to take a chance? That's up to that should be a decision that's made at that level. And of course, if you're not getting them to pay attention, you can remind them that they may face personal liability under the directors and officers liability at CASL. Second, conduct an audit. Okay. Ask yourselves, go through your email, your electronic databases, and ask yourself the following question. What types of electronic communications do you send out? Okay. And to who? Okay. Do you communicate on behalf of other organizations? And if so, who? Because there's that you can be held liable under CASL for basically if you communicate on behalf of someone else and you do not comply, then they may be held liable and they can come after you. So you have to be careful about that. What third parties send electronic communications on your own organization's behalf? So it goes both ways. So if you're hiring someone to do your electronic communications, an external party, you need to make sure that they're complying with CASL, because if not, you may be found liable. So you got to be aware of that. To whom do you send electronic communications? That is so important. What is your list of recipients? What does it look like? What type of communications do you send out? What does it say? Okay, and what is the purpose of sending those electronic communications? That, of course, goes to the most important part of the charities exemption, which is the primary purpose of raising funds for the charity. So do an audit. The audit is very important. And once you've done an audit, you kind of get a sense of what to do next, okay? So once you've done an audit, I would recommend develop and implement a CASL compliance policy and procedure. As a reminder, why you should do that? Because of the due diligence defense. It's a defense to CASL. So if something goes wrong, you can fall back on your policy and say, hey, we did this. We worked on this. This was just a one-off mistake. It won't happen again, okay? And with regard to compliance policies, here's some examples of the stuff you can do. You can develop procedures for requesting, maintaining, and implementing consents, keeping track of implied consents, remember that 2 years, so keeping track of the 2-year period, and implementing unsubscribe requests. You want to develop and implement CASL compliant language in your request for consent, and that's essentially very broad stuff that you should be including in your policies. Training and education. So it's not enough to have a policy, to write it down. You actually have to train and educate the people who are communicating on your behalf. They need to know what to do. They need to know, here's your CASL compliance policy, and this is how you comply with it. So you do a training program. You ensure all new hires or volunteers receive the program, and you consider training third parties if they're communicating on your behalf. Review your contracts with third parties and make sure that it has a CASL compliance and indemnification provision. What does that mean? Well, again, if you have third parties communicating on your behalf, for example, a marketing company, right? You need to make sure that in the contract with them, it says you guys have to comply with CASL when you're communicating on our behalf, or if you don't and we are then facing liability, you will indemnify us, right, for for that liability. So that's, I provide clients with language to that effect all the time. Consider buying insurance for CASL. I get this question a lot. Is there insurance? From what I hear, it's not so easy to find insurance for CASL, although insurance companies, you know, D&O insurance might have some premiums for that. I don't know, and I'm not involved in any of that, but I hear that it's possible to find it. It's just not easy. Consult with IT specialists. Especially if you're a big organization, there's going to be some IT requirements involved in this in terms of getting compliance, you're putting into place your compliance policies, whether it is setting up a CRM, connecting your CRM with your electronic data provider, let's say it's your email provider, etc. So there's some IT specialists that provide consultation services, and I know some, and if you can always ask me, I can send you some names of people or companies who do this they're all aware of CASL or should be aware of CASL and help you with implementing your systems in a CASL compliant way. So that's a suggestion. So here's a list of the other, very, very briefly, other types of CASL requirements that you need to be aware of. I'm not going to get into those, but I am going to, as I mentioned earlier, going to spend a few seconds on talking about one important part of CASL that you should be aware of, and that is electronic collection and use of personal information and address harvesting. So CASL prohibits anyone from using electronic systems, so it has to be electronic, to collect and use personal information and email addresses without the express consent of the person whose information is collected and used. In other words, you can't go out there, use a software, there's a lot of softwares out there that do that, and you can't do that, to collect the person's email address without getting their consent first, all right? That's what we call email harvesting, right? It's these software that goes out there and collects email addresses from all over and just then puts together a list. Don't do that. It's not allowed, all right? So consider eliminating that practice if you are doing that, okay? So here's a list of some of the stuff I can do to help you. I can help you with your audit. I can help you with putting together a CASL compliance policy. I could give you some consultations, answer your questions. I have done many compliance policies for nonprofits and charities. I've got lots of templates for those. I could train your employees. I also, if you are unlucky to show up, have the CRTC knocking on your door or have a lawsuit at some point, then I'm happy to help you out with that too, although I hope you don't get there. So that's kind of the stuff I can help you with. And as I mentioned earlier, you're more than welcome to contact me for consultations and or to hire me for consultations if you want answers to some questions. So that's my contact info. We have 17 minutes for questions. So I'll take some burning questions. And I'm sorry I ran through this, but I know it takes time.
Well, Manit, we want to say thank you so much for an informative presentation. We've gotten tons of great feedback already, and we've been polling the audience for questions throughout. There are many, so we're going to get through as many as we can right now. And if you've not yet answered your questions for the speaker, please do so now by using the questions chat box in your GoToWebinar panel. Okay, our first question is from Dory. We have many clients that are existing families in our child care center. Can we assume implied consent for those families?
No, don't assume implied consent. You would need to consider the relationship, consider who you are, what you are in terms of whether a nonprofit or a charity, and then I got to see how they are related. What's the legal relationship? So the bottom line to answer to that it's a very specific question. You would need to, if you like an answer to that, I would recommend hiring me for a consultation because you need to look at the relationship. So I won't say there's implied consent until I know the relationship. That's the answer.
Okay. The next one is from Nancy. How do we prove verbal consent?
Oh, that's a good question. Okay, so according to the CRTC, I'll go by what they say, if you are going to get consent orally, for example, on the phone, there has to be a third-party verification. In other words, you should either record it or someone else has to be in the room to give evidence about the fact that you got consent. So in other words, not very not very practical. What I tell clients when I do policies for them that they want to get consent from someone over the phone, then the best thing to do is to have a recording, and of course tell the person you're talking to before you do that they're being recorded. So that's the best way to record oral consent. The other way to do it is to, let's say you're talking to someone on the phone and they say, hey, you say, oh, can we send you some our emails going forward to tell you about the stuff great stuff that we're doing? And they say yes, and you can say, you know what, could you do me a favor? I just, I need confirmation. I need your email. Can you email me, please, just saying that you consent with your consent? And then once you get that email, great, you're good. Right? So find ways to confirm. If you're in person with a person, face-to-face in a meeting, have a sign-up sheet that's here that says, click, fill in your name here to give us consent to send CEMS. So figure out a way to get it in writing or to get some kind of third-party verification.
Okay, this question is from Trudy. Does CASL have any relevance on emails originating outside of Canada?
Yes. So CASL applies to any electronic message sent to someone in Canada. So it applies to anyone who sends from outside of Canada to someone in Canada. The recipient has to be a Canadian, has to be in Canada.
Okay. From Jamie, may we send them an email confirming that we have removed them from our mailing address? The mailing list.
No, do not do that, no. I would say, first of all, why? Well, hold on. It depends on the circumstance. It really depends. Are you asking about an unsubscribe? So, for example, someone unsubscribes and you want to send a confirmation saying you have now unsubscribed. You can do that within 10 days because if you remember an unsubscribe, you need to implement a subscribe within 10 days. So that gives you 10 days to send them an email. But just sending out random emails saying, hey, we've removed you now. If you don't have implied consent, don't do that. My suggestion would be no.
All right. Great. From Adam, can consent to receive CEMs be combined with another consent, for instance, release of information, or must it be a separate signature?
Separate signature. The CRTC has made that very clear.
Great. From several attendees, Manit, would you be able to share a sample CASL compliance policy for us to reference?
No. The short answer is no. Okay, so a CASL compliance policy is really tailored to each organization. Okay, just like you look at privacy policies, each organization has its own. They're very specific, very unique. I don't like recommending any. I've done a few for quite a few organizations. I'd rather not say which they are because I don't have their consent. But very large umbrella organizations and small ones as well that I've drafted templates for, and each one is different. So unfortunately, I don't want to say, hey, yeah, go here and copy. You shouldn't. You should be developing your own. So sorry. Oh, and one more thing, unrelated entirely. I just want to go back to the express consent thing that I remembered that I don't include in my presentation, but may answer some of your questions. And if not, you should be aware of that. The CRTC makes a big deal out of pre-checked boxes. What do I mean by that? The CRTC says that anytime you want someone to give you express consent electronically, like with a check box, like click here to get to consent to get to hear from us or get our communications, you need to make sure that that box is not pre-checked. If it's pre-checked, the CRTC says that's not express consent. You have to give them the physical ability to check the box. So keep that in mind. I know it doesn't answer the question, but I just kind of wanted to put that in there in case there is a question about that.
Sure. Okay, this is also from several people. Can you talk about social media and CASL? For example, are promoted Twitter or Facebook ads the CEMs?
Right. Excellent question. Okay. So social media is a bit of a I don't know the word I have in mind I shouldn't say because it's a bad word, but it's problematic. And what do I mean by that is that the way CASL is written, it's written to cover social media, yet the CRTC has not really figured out how to deal with it, because when CASL was drafted, it was before they even thought of social media. They just keep in mind that CASL, they started drafting CASL like 2000 and I don't know 3. So it's an odd sort of space where really we don't know as how far it goes in terms of social media. But here's my take on this. First of all, while the definition of CM would sort of technically cover a tweet, the CRTC has said, and that we can go by that, that posting something on social media, like a public posting, so would it be a posting on a wall, a Facebook wall, for example, a Twitter feed, or on LinkedIn, you know, a status update on LinkedIn, for example, or Instagram, that the CRTC said is not a CEM because it's not sent directly to someone's electronic address, it's just kind of published online. So therefore it wouldn't, so a tweet technically wouldn't be a CEM, a Facebook posting wouldn't be a CEM, LinkedIn status update wouldn't be a CEM. It is a CEM, however, according to the CRTC, if you use social media to send a direct message to someone. So sending an instant message through Facebook is a CEM. Sending a message through Twitter directly to someone is a CEM, or sending, again, example, a LinkedIn message to someone would be considered a CEM. So that's the first thing to know about social media. So if you're talking about just posting something on your wall or someone else's wall, that's okay. It's not a CEM. Then when it comes to these actual instant messages, so let's say you do a instant message through Facebook to all your Facebook people who are following you on Facebook, and you want to send them an invite to something. That would be a CEM. However, if you go back to the complete, let's see, where is that exemption? There's an exemption here called, here, the number 8 here, CEM sent within it. So there's one exemption that we don't know what it means, but this is what I think it means, okay? CEM sent within an electronic platform where unsubscribe and identifying information is conspicuously published and readily available. So I interpret that, and the CRTC hasn't been forthcoming in saying if they agree. So I can't say they'll agree, but I think it could be argued that essentially applies to sending CEMs through social media to anyone who is, you know, a follower. Because really it's sending a CEM within an electronic platform where the unsubscribe and identifying information is conspicuously published and readily available, right? Because anyone can unsubscribe by unfollowing you, right? And anyone can unsubscribe by, you know, not being your friend anymore. So there's potential to argue that exemption applies to these types to social media, but it hasn't been tested yet. And the CRTC has not given any guidance on that. So the answer is social media isn't as concerning as email right now, simply because A, a lot of it doesn't cover CEMs, and B, there is this exemption. So it's a better world to be in, but you have to be careful.
All right, great. Next question is from Patty. How would you recommend that I reach out to my newsletter list now to ask them to confirm their consent? Oh, that's a loaded question. I'd say contact me for a consultation. You should not, okay? Your newsletter, what you have to do is basically go back and do an audit, go through the list and find out who you already have consent from, whether express or implied. And if you don't, then, and this is assuming you don't have, you're not subject to the charities exemption. In other words, the newsletter you're sending is not, does not meet the charities exemption. Then if you don't have consent, either express or implied, based on the relationship, then you take them off the list. All right. From Cheryl, is an email to our members about our annual educational conference considered a CEM?
It depends what it contains. So if you are promoting an organization in there, and there are services that you provide, and they're commercial, it could be commercial in nature in one way or another. It doesn't have to be for free. It could be, sorry, for pay. It could be for free. It could be a CEM. It doesn't. I'd have to look at that. Okay. But if it is, because they're your members, it doesn't matter because there's implied consent. So as long as you have the unsubscribe mechanism in there, you can send it, right? Because as I said, if you're a nonprofit and they're current members, you have implied consent.
All right. From Sharon, you mentioned that an exchange of value couldn't be free. For example, if people provide their email to download a free publication, does that mean they have created an existing business relationship or not? No
existing business relationship. That is a question I've gotten many times from clients, and that's an absolute answer. I'm very comfortable with saying no. The CASL is very clear that there has to be an exchange. At least that's my interpretation of CASL.
Okay, this is from ALID. Our organization does not have a membership per se, but we consider anyone who has participated in our programs a member. Does this apply to implied consent? In other words, communication for 2 years?
Yeah.
at the
Okay.
end of the
So you need to look at the organization and its bylaws, and you need to figure out whether or not they say that this person meets the definition of member under CASL. I can't get into that right now because I have 5 minutes. There's a particular membership base requirement, but I'd have to look at what services your organization provides, and how someone becomes a member, and in what, what creates that membership. You can't just automatically say, oh, this person attended something, so they're a member. There has to be something that sets out why they're a member, and there's a whole criteria to that. So without giving you too much detail, I'm just going to say, don't assume you have implied consent. You got to look at it.
Okay. All right, this is a question from Ryan and a similar one from Deborah. What's the best way to monitor the network of volunteer associations that send out emails on our central organization's behalf, and who would be held most responsible, them or our office, should they make a violation?
First of all, I'll answer your second question first. The answer to the second question is both of you. Okay, because under CASL, both the sender and the person on whose behalf the message is sent can be found liable under violation of CASL. So both of you. The best way to do that, I mean, each organization is different, and you got to sit down and figure it out. But what I've done with my clients before is in the CASL compliance policy that we've developed, there's very clear language about what volunteers can and can't do, and they require all volunteers, as soon as they agree to do this and send out electronic messages, to comply with that.
Right. All right, this question's from Sue. Is consent transferable? We are a third-party for-profit business that works on behalf of a not-for-profit or charity. Can we send CEMs on their behalf?
Again, so as I said before, anytime you send something on behalf of someone else, both you and yourselves are liable for those for CASL compliance. So the consent, it depends on the situation, but for example, if you're like a provider for nonprofit, for your clients, you're providing the services sending of the electronic messages, then the organization on behalf of whom the message is being sent has to have consent. So as long as your client has consent and it's clear from the message that it's not you sending it, that the message is being sent on their behalf, that's okay. But if it's sort of a combined thing, then there's going to be consent for both of you. So it really depends.
Okay. From Diane, how long do you need to keep consent records for?
Oh, that's a very good question. And the answer is, we don't know. It's like so many things about CASL we don't have answers to. It's a problem because CASL right now has a limitation period associated with it of 3 years, but it's unclear whether the limitation period is for I'm not sure if it's for the regulatory proceedings or for the civil actions, which haven't started yet. Okay, so at the minimum, I'd say 3 years. At the minimum. Now, the problem, of course, comes up is with privacy legislation, which says you shouldn't be keeping records for longer than you need to. But CASL, because CASL is essentially related to the privacy legislation, I'd say that kind of falls outside of it. So, as I said, the minimum is 3 years for CASL purposes.
Okay. This one's from Nancy. We have a large database of people who have opted in to receive our quarterly newsletter. Separate from the newsletter, can we send them a solicitation email for specific fundraising activities?
Well, again, I do not want to answer that question because it's very specific to your organization and it can't be giving you legal advice. All I can say is if you're a registered charity and those emails you want to send out are for the primary purpose of raising funds for the charity based on the wording of the emails, then you may rely on the exemption, right?
Tim wants to know, where do CASL fines go? Who gets the funds?
Oh, from the fines? That's the question? The government. Hopefully the taxpayers at some point. Hopefully.
Yeah. And then I think this is the last question we have time for. From Jennifer, is the privacy commissioner at the federal level? How does it work with provincial?
It's the federal level. So CASL is a federal legislation, and the privacy commissioner that has been tasked with enforcing the privacy part of CASL is the federal body. Okay.
All right, that is all the time we have for today. I want to thank Manit for walking us through Canada's anti-spam legislation and Volunteer BC for sponsoring today's seminar. And I'd like to thank everyone for taking time out of your busy day to join us. Just a reminder that the webinar recording will be posted on our website shortly. Also, please do fill out the brief post-webinar survey that will launch after the session if you have additional questions or if we weren't able to answer your question today. Thank you, everybody. Have a great rest of your day.
Thank you. Thank you, Ben.